Here's PragerU to whine about all the most awesome things that the Supreme Court has done.
How did the framers of the Constitution of the United States seek to preserve liberty and prevent tyranny? Pretty basic question. Here's the answer I usually get from my students. Well, Professor, to protect the individual and minorities against the tyranny of the majority, they added the Bill of Rights, and they gave the power to enforce those rights to the Supreme Court.
Do they really say that? Because no court enforces anything. They issue orders to enforce laws and rights. If the Supreme Court had the ability to actually enforce their rulings, then they would have been able to stop Andrew Jackson from sending indigenous people down the Trail of Tears. Chief Justice John Marshall ruled that Jackson could not legally remove these folks from their land, and Jackson said, "John Marshall has made his decision, now let him enforce it." By that he meant that the Supreme Court doesn't actually have a mechanism to enforce their rulings, and it is actually just up to the government to abide by them. However, for an executive or legislative branch of government to ignore the Supreme Court is essentially for them to say that they are either above the law or the Constitution, or that they think that governments should be allowed to interpret that law or Constitution however they like with no judicial check on their power at all. This seems to be PragerU's stance, at least whenever it comes to Republican-controlled governments.
Are my students correct? The editorial boards of the New York Times or the Washington Post and many members of the U.S. Congress would say yes. Unfortunately, the answer is wrong. I say unfortunately because it reflects a common misunderstanding of the Constitution, and that misunderstanding has led to a serious erosion of our freedom. Let me explain. Both the Bill of Rights and judicial review, the idea that the courts can decide if a law is constitutional or not, were hotly debated items when the Constitution was being drafted in 1789. The Federalists, the group led by Alexander Hamilton that wanted a national constitution, opposed including a Bill of Rights. They feared it would actually undermine what the Federalists regarded as the main protections against tyranny in the document: the limited nature of the national government itself.
There were folks who feared that if you made a list of specific rights, that would make people think that such a list would be exclusive. They worried people would think that if a right wasn't explicitly listed, then it doesn't exist.
The Constitution did not envision a national government of general jurisdiction, meaning a government that could do whatever it wanted, but rather a government of enumerated and delegated powers. A government that had authority over only specific areas of American life. All other powers were to be beyond the scope of the national government and reserved to the states or to the American people themselves.
Ironically, it is conservatives who seem most eager to use the argument that a right doesn't exist if it isn't explicitly listed in the Constitution. They often say things like, "There's no right to be gay in the Constitution," "There's no right to gay marriage in the Constitution," "There's no right to reproductive choice in the Constitution," and so on ad nauseum.
That's why when political necessity forced the Federalists to yield to demands for a Bill of Rights, they took care to add two important amendments, the 9th and 10th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. These amendments reinforce the idea that the national government couldn't just assume powers it had not been specifically granted by the Constitution. Unfortunately, these amendments have not stymied the expansion of the national authority.
Another amendment, which conservatives would seem to want us all to forget, is the 14th Amendment, which says that any right Congress can't take from you, state and local governments also can't take from you. Often when Republicans talk about losing liberty, they mean that states are no longer allowed to impose draconian laws on people. They think that people gaining liberty from state and local governments is a loss of liberty.
The power grab the Federalists feared, the national government taking more and more control over more and more areas of American life, took place. Not immediately, but over time, and especially beginning in the second half of the 20th century. That same time frame has seen a similar concentration of power in the judiciary, especially in the Supreme Court, so that now most Americans think of the Supreme Court as the ultimate arbiter of almost every social and political dispute. The founders never envisioned the court in this role. How has the court fared in playing it? Well, there have been moments of glory, to be sure, such as in the racial desegregation case of Brown against the Board of Education in the 1950s.
Which, by the way, was not decided on the basis of the 9th or 10th Amendments, but rather the 14th. That's the same amendment on which the court based their decisions in Roe v. Wade and in Lawrence v. Texas and in Obergefell v. Hodges. But I'm sure PragerU would like us all to believe that the same logic ought not apply in those cases for some reason.
But it has also handed down decision after decision, from Dred Scott against Sanford in the 1850s, which facilitated the expansion of slavery, to Roe against Wade in the 1970s, which legalized throughout the United States, in which the justices have plainly overstepped the bounds of their authority by creating law from the bench.
That's clearly the case in Dred Scott, given that they basically made up a law that says that you are not allowed to steal yourself from someone who owns you. But in Roe v. Wade, a law was stricken down rather than created. It didn't take away anyone's liberties, it enhanced liberty,
thereby further expanding their own power and that of the national government. Moreover, the Supreme Court has done little to stop the executive and legislative branches of the national government from unconstitutionally overreaching. Recently, the court found a way, by a bare majority, to uphold an obvious case of constitutional overreach by the national government, the imposition of a law, or individual mandate as it is known, requiring every citizen to purchase health insurance coverage as part of President Obama's signature Affordable Care Act.
Well, Chief Justice John Roberts, a Bush appointee by the way, ruled that since the Constitution explicitly gives the federal government the right to impose taxes, the individual mandate is constitutional. It doesn't actually impose a legal requirement to buy health insurance. If you choose not to buy the health insurance, you won't be charged a fine, you won't go to prison, you are not breaking any law. Roberts said that neither the Affordable Care Act nor any other law attaches negative legal consequences to not buying health insurance beyond requiring a payment to the IRS. To say that the individual mandate is requiring every citizen to purchase health insurance is like saying that levying income tax is requiring everyone to make less than the minimum taxable income, or that sales tax is requiring that people not buy things. The fact that you have to pay more in taxes if you do something or abstain from something is not the same as a requirement to not do or not abstain from that thing.
The government defended this mandate as a legitimate exercise of its expressly delegated power to regulate commerce among the states. The trouble is that the mandate does not regulate commerce at all. Rather, it forces people into commerce on pain of a financial penalty.
First of all, I don't see why regulating people into commercial activity doesn't count as a regulation of commerce. Secondly, that's not the only argument the government made. As I already explained, it was the taxing and spending clause that the court said makes the mandate constitutional, not the commerce clause.
But why did the issue get to the courts at all? Congress and the president should have recognized and honored the fact that the Constitution simply does not empower the national government to impose a mandate on the people to purchase products, whether health insurance or anything else.
But by taxing people and spending those taxes, the government is already forcing people to purchase products. When you pay your taxes, you are purchasing the services of the government, and you are forced to purchase the services of the government.
We've drifted a long way from the original vision of the founders. The further we've drifted, the more powerful the national government has grown, and the less free Americans have become.
Since the latter half of the 20th century, the Supreme Court has actually increased the liberty of Americans by not only limiting what the national government can do, but also what state and local governments can do. If you're black, gay, or end up with an unwanted pregnancy, you have significantly more freedoms than you did before Brown v. Board of Education, Lawrence v. Texas, or Obergefell v. Hodges. And these are all cases that were decided upon based on an interpretation of the Constitution that PragerU rejects. To everyone who helps me out on Patreon, you're a big help. Thanks so much.